Roland Mumford with Mumford.law. What is litigation fatigue? Litigation fatigue is something that defense attorneys in civil litigation rely upon, knowing that a plaintiff, that would be you if you were filed a lawsuit, that you get exhausted with the case. Litigation is long, it's protracted, it's tedious, and at the very beginning of a case, when you hire an attorney, you're very motivated. You're still pissed off and you want to seek justice. And particularly in federal court litigation, when a federal complaint is filed, we got to get scheduling orders into place. And then we get into sometimes dispositive motions that are filed early before you get into written discovery. And it can be a number of months before you get into written discovery. And clients can sometimes become frustrating. You're exhausted, you have children's, you have the activities you got to deal with, the extracurricular activities, that is. You're exhausted from your job. But on that discovery, you have a deadline of 30 days. And sometimes your attorney can get 14-day extensions or maybe more. And what happens is you find it difficult to be able to cooperate and comply with attorneys' requests in producing necessary documents, coordinating with their paralegals or the attorney themselves, and drafting interrogatory responses. And interrogatories are those written questions. And then, of course, there's requests for documents. And sometimes that can affect the attorney-client relationship. And that's why we always advise that it's important at the very beginning of the case to work with your attorney to start answering the boilerplate discovery questions that the attorney knows is going to come, particularly in 1983 litigation or an employment law litigation. There are 2/3 of the questions that you're going to get from that defense attorney representing the employer or the police officer or police department. They're going to be the same questions. And so go ahead and start at the very beginning to get the information and the responsive facts outlined, and where you have a few months to do it and you're not under the gun within that 30 or 45-day period to respond. Another thing that's important to remember is I'm kind of dealing with this situation right now where, when a client doesn't want to cooperate and we can't get the discovery responses out, well, then you can't go to trial because you can't put on the facts and the proof at trial, because the defense is going to raise the objection and say, hey, we asked you these questions, we asked for these documents, you didn't produce them to us in discovery, therefore the court is going to not allow you to put that proof on. But let me tell you about something else that's extremely important, and that is responding to requests for admissions. Requests for admissions are, for example, please admit that on this date this occurred. Please admit on this date you communicated with this person this particular manner and this was the content of the message. Or please admit this certain fact. If you do not admit or deny those responses and get them back to the defense within 30 days, then the defense is going to move the court to have them, quote, deemed admitted. And then that will pretty much destroy your case. If your failure to respond with an admission or a denial, and if those facts that they're trying to have deemed admitted hurt your case is pretty much over. So it's always very important to cooperate and comply with your attorney's requests timely. Everybody has a job, but the deadline set by the court doesn't care about you having a job or your children's extracurricular activities. So next to a car wreck or being ill or some other type of emergency, you're not going to be able to show good cause to extend the deadlines. Always important. Cooperate and comply with your attorney. Have a great day.